Good morning. Hello, and welcome to Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you, everybody, so much for being here. This is going to be a good one. I am juiced. Kaylin is juiced. Tiffany is juiced. The mods are juiced. Afton's here. Hello, CC crew. She's juiced. Everybody's ready to go. Who do we got in the chat already? Jenny G and Stefan and Kathy and Alicia K. Mayo and Bess Nancy and Crazy Mom RN and Kimbers, Ohio. Thank you guys so much for being here. This is going to be a good one. This is going to be a really good one. That I've gone through your questions that we're presenting today, and I'm really happy with a lot of these questions. I'm always happy with the questions. You guys ask incredible questions, and it's stuff that there's always something I never would have expected. Hello, Miss CC and Bess Nancy. Good to see everybody this morning. All right, here is the plan. First, take a moment to hit the like button. Take a moment to subscribe if you haven't already. That is what helps us get this show running. For those of you who are new, and I see some names that I don't recognize, so thank you so much for being here. My name is Joshua Ritter. I am a former LA County District Attorney, a prosecutor. I was there for about 10 years. Actually longer if you include my time as a law clerk. So I was there for a long time. And then I went into private practice, and I've been a defense attorney for nearly as long. This is Courtroom Confidential, where we do our best to give you a perspective from both sides of the courtroom, and we hope that we do that. We are going to, because this is Sunday Funday, we're going to answer voice messages that you guys have left throughout the week. We did our best to answer as many of them. If we didn't get to yours, please don't throw things at your computer or TV. We will get to them next week if we can, or the following week. I tried to cover at least every topic that was asked, but you guys asked a lot of incredible questions. And then stay to the end for some announcements, because we've got some big ones coming up. That's everything I got to say. Let's go ahead and just jump right into this. Oop, hold on. There we go.
Good morning, Josh, and everyone at Courtroom Confidential. This is Marie Jubenville in Birmingham, Alabama. I have a question about something that has happened recently in Arizona. In Arizona, during victim impact statements, the family of the victim of a road rage incident had an AI-generated image of him on the screen giving his own impact statement. 1, do you think this should be allowed? And 2, do you think in a case where the death penalty is on the table and the victim is a child, such as in the Maddie Soto case, if this would impact the jury to vote more likely for the death penalty versus life in prison, especially since in Florida, they only need 8 people to vote for the death penalty? Thanks, Josh, for answering my question. I really love your channel. Thank you. Bye.
Thank you so much, Marie from Birmingham, Alabama. I appreciate you kicking us off. Great question. And this is not going to be first of all, let's put Birmingham, Alabama on the map. Everybody who calls in, tell us where you're from, and we're going to put you on this map. Look at this map. Can we zoom out a little bit, Kaylin? Look at how filled up this map is becoming. It's incredible. Thank you for that question. I love this because I did see this about AI being used for a victim impact statement. And just to show you that things don't always begin as you had hoped, I told Kaylin, I don't think we have anything that we need to play this morning. And I lied, because the very first question, I have something I want to play, but I think I've got it figured out, Kaylin. So let me figure out how to do this myself. Kaylin's laughing at me. You guys can't see, but Kaylin's already laughing at me because this is something we should have figured out ahead of time, and I didn't. All right. Watch this video. It's pretty incredible, guys.
Stacey Wales has plenty to remember her little brother by.
This is his dress uniform.
But she'd trade it all to have Chris Pelkey back.
Trying to make this come to life and to lift him off the page in the best way that we could that's available to us now.
Pelkey survived multiple overseas tours in the military, but back home in November of 2021, he was leaving a church softball game when he was killed in a road rage shooting at Germain and Gilbert Roads in Chandler. His family endured a grueling legal process, 2 trials over 3.5 years. Last week, Gabriel Horcasitas was convicted of manslaughter. Before sentencing, 49 victim statements were shared. Stacey spent 2 years working on hers.
All I kept coming back to was, what would Chris say?
As a tech-forward family, Stacey and her husband Tim worked regularly with artificial intelligence. So Stacey suggested letting AI generate a victim statement directly from the victim through modern tech beyond the grave.
It became so real that I broke down in tears.
Tim prompted AI with old video, audio, and a good photo of their brother. It took a few days. Their victim rights attorney, Jessica Gattuso, was reluctant at first. Is this even legal?
Our law in Arizona says that victims can give their victim impact statement they have the discretion to choose how they give their victim impact statement. And this is how they chose to do so. So yes, it's absolutely legal.
Here's Chris in a real recording before his death.
Just like Jesus says, love God and love people.
And here's the AI version, forgiving the shooter, scripted by Stacey.
It is a shame we encountered each other that day in those circumstances. In another life, we probably could have been friends. I believe in forgiveness and in God who forgives. I always have, and I still do.
I love that AI. Thank you for that.
The state asked for 9.5 years. The judge gave 10.5 for manslaughter. We asked the Arizona Supreme Court about the general use of AI in courtrooms. Justice Ann Scott Timmer said AI has great potential, but also risks if misused. For the Pelkey family, they found justice and a measure of peace, especially after one of Stacey's children reacted to seeing Uncle Chris one more time.
Mom and Dad, thank you so much for making that. I needed to hear from Uncle Chris one last time. And that meant so much. Thank you. And that is not what this was intended to do, but the result of having it be a healing piece for anybody who saw it was just such a beneficial result.
Is that absolutely wild or what? So, yeah, I mean, I'm not going to re-explain what you guys went ahead and already watched in the video. And Janet Stubbard says, please explain AI and how it is used. Don't get it. Well, you're seeing it partially at use here, Janet. What they were able to do, and this is incredible, in this case where this man was unfortunately killed during the victim impact statement portion of sentencing, which is every sentencing usually allows for this in some respect. They thought to themselves, what better way to show the impact and allow the victim whose life was taken to speak than to go ahead and generate this video. So what they did is they took his photographs and they took a script and they were able to take his voice through AI and have his voice speak the script and then have his face there actually speaking those words to be played in court. I'm blown away by it. One, I'm blown away by it because of the technology. I mean, it's just becoming so good that it's really, if you've seen some of the new AI stuff that's online, it's hard to spot that it's AI. We're living in very, very wild and troubling times. And then the idea of using this during a victim impact statement. And Marie, thank you for asking the question. Ask, first of all, should this be allowed? Well, legally, I don't think there's a problem with it. I think, though, obviously some discretion should be used because you certainly don't want a situation where, as it appears as though it's making light of a situation. I don't think that happened here at all. I obviously everyone was very touched by it, and I'm glad the family was able to do that. And then Marie says, what about in a death penalty case? And that's a really interesting question too, because now you're talking where the stakes are even higher. And are we manipulating, I guess is the question. Are we manipulating the emotions of the jurors by having something like this take place? Imagine a death penalty case involving children that were killed. And imagine having AI used to have those children speak and make a plea to the jurors. That to me might be going too far. And I could see a judge using their discretion to not allow it in that type of situation. But with these advancements in AI, I would not be surprised if we start seeing this more and more. That was absolutely incredible. And also really thinking outside of the box for the family. So good for them. Incredible story. Marie, thank you so much for bringing that up, because that was something I actually wanted to bring up during maybe like a Wednesday night live or something. And I'm glad that you reminded me about that case. All right. Oh, wow. Court Lurker says Long Crime is recreating the Diddy trial from court transcripts in AI. Oh, I think I've heard that. They're doing it in audio only. I think I've heard they're having portions of the trial read through AI using the voices of the people, the witnesses, to actually read it out. I've seen that. Wild stuff. We're going to start seeing this more. By the way, I welcome our robot overlords, but this is the future, everybody. All right, now that I messed everything up, let's see if I can get us back on track as far as sharing my screen here. All right. Add to stage. Here we go. All right, let's keep it moving.
Hi, I'm TJ from Oakland, California. I saw that in the Bryan Kohberger case that the judge is bringing in a special prosecutor to investigate whoever leaked the confidential evidence to Dateline. Shout out to the great folks at Dateline, by the way. But here's what I'm wondering. Dateline isn't under the gag order. I'm pretty sure, but I'm not 100% sure. So they are allowed to air stuff that, even though it was illegally leaked. Otherwise, they wouldn't have done it. But even if it broke the rules, can the court actually make them say who gave it to them? Or does that fall under journalist protection laws? I'm just curious how that works when the media gets info they shouldn't have.
TJ from Oakland, California, let's put you on the map. I love this question as well. This was another thing I wanted to research myself, and I kept on putting it on my things to do list, and I'm glad that you asked the question because it forced me to go ahead and get that done. TJ is talking about the Bryan Kohberger case. We all saw this Dateline leak. I've done a couple of episodes on it now. I do think it is pretty bombshell that was leaked. And now the question becomes, what are the consequences? What is going to be the fallout? What will be the problems either in the trial? What will be the consequences for those involved in leaking it? Of course, whenever we talk about this case, I want to take a moment to mention the beautiful victims who lost their lives: Kaylee Gonzalez, Madison Mogan, Xana Kernodle, and Ethan Chapman. Here is TJ's question, and this was the Dateline episode called "The Terrible Night on King Road." And her question is, the judge is upset about this, and the judge is saying, I want an inquiry done. And the judge has suggested even to the prosecutors that I want a special prosecutor assigned to this, meaning an independent investigating unit, not the prosecutor's own office. That's what they're talking about. We don't want you to investigate yourself. We want you to appoint someone independent, a special prosecutor, to look into this, to see where this leak came from. Did it come within the prosecutor's office? By the way, suspicion should be equally placed upon the defense if the defense leaked this, or some other source who may have had access to this information. But let's say that they can't figure it out, and it all comes down to Dateline and asking Dateline, where did they get their source from, and asking Dateline to give up their source. Dateline's not going to do that. So what happens? What happens when these loggerheads meet and the judge is saying, I want it, and Dateline's saying you can't get it? And best gun losing detective makes a great point too. This just makes metadata more important. You're right. You cannot leak anything anymore without tiny little digital fingerprints being attached to it. So maybe they'll be able to figure out where it all came from that way. Great point. But what happens when you've got a Dateline producer standing in court and the judge is, pounding on their desk saying, give it up, give up your source? There are what are called media protection federal, they're called shield laws, essentially. They shield the media from having to give up sources. First of all, there is no federal shield law. So if you're in federal court, different rules. And there's no rule that applies throughout the entire United States. So it's up to each state how they decide to go ahead and do this. What's fascinating is, I obviously not in anticipation of this, but Idaho just passed a law in March regarding their shield law. It's Idaho Bill 158. It was passed March 27th of 2025. Get this. It does not become effective until July 1st of this year. So it is not effective for the next month. Now, I don't believe the judge is actually going to say, well, that law is not in effect, so I'm going to force you to hand over your sources. I don't think the judge will do that in this case. That law will become into effect in July, and what it does is protects the media from compelled disclosure of confidential sources in any legal proceeding. It's for exactly this. A judge cannot force you to hand over your sources if you are a media outlet. But I just did think it was interesting that law was recently passed and not entirely in effect until a month from now. Happy June, everybody. June 1st today. So great question, TJ. The answer is the judge can't do anything. And I don't think the judge will say, well, that law's not in effect yet. Go ahead and hand over your source. I think the judge really wants this to be done by the DA's office, a special prosecutor, whoever's going to make an investigation. And I was pointed out by another comment, probably metadata will play a large role in this. So thank you so much, TJ from Oakland, for asking that question, for making me finally look into that whole issue. All right, let us move on to our next caller here.
Hey, Josh, this is Katie from Fort Smith, Arkansas, and I was reading the Book of Murder, and I just finished it. I have to have another recommendation. It was so great. Let me know. Hopefully Tiff can help. Thanks. Bye.
Katie from Fort Smith, Arkansas. Thank you so much for leaving the question. First of all, let's go ahead and get you on the map here. Fort Smith representing Arkansas. Katie references the Book of Murder, which was written by a very good friend of mine and a brilliant prosecutor by the name of Matt Murphy. We've had Matt on the show. We've interviewed him before. We did one of our conversation. Did we do one of our conversations with Matt? I think we did. Yeah. One of our conversations with Matt. You guys can check that out. Matt's a brilliant guy with a really interesting history in the DA's office in Orange County, the neighboring county from where I worked. I've known him since the time I was a prosecutor and he was a prosecutor. Always looked up to him, always considered him to be a colleague and a mentor of mine. And he prosecuted some really high profile, incredible cases. He is the real deal. And he has now gone into private practice like myself, and he's involved in media, and I think he actually does Dateline, I think is the show that he works on. But he also wrote this book called The Book of Murder. I will tell you, just because you're a brilliant lawyer doesn't necessarily mean you are going to be a great writer. He's a great writer. And I asked him flat out, did you actually write this thing, or is this one of those ghostwriter type situations? He wrote this, and it is a really fascinating read. I mean, he makes these cases. What he does is walks through a lot of cases that he worked on as a prosecutor and makes them come to life. And he did some really fascinating ones. And I think the ones that were most interesting to me are the ones I'd never heard of. I mean, just some really gruesome, horrible stuff. And he talks about the process of actually proving those cases in court, which is something that I love a lot. So great, great book. Katie, thank you for bringing it up. And then Katie says, what is your next recommendation? And ask Tiff if you need help. And I did ask Tiff, and she reminded me of a book that I really love called The Lincoln Lawyer by Michael Connolly. Michael Connolly is one of my favorite authors. He does a bunch of series. This is the Lincoln Lawyer series. The first book is called Lincoln Lawyer, about a criminal defense attorney named Mickey Haller here in Los Angeles, who, just kind of his adventures defending different clients throughout Los Angeles. And they call him the Lincoln Lawyer because he has a driver who drives him around in a Lincoln because he's so busy. He has to be making phone calls and reviewing cases, and he needs a driver to get him from courtroom to courtroom. I really love it because it's about what I do as a criminal defense lawyer here in Los Angeles. Michael Connolly is also an incredible writer, and he also wrote the Bosch series. A lot of books about the world of crime. They're obviously all fiction books, but they are all kind of in Los Angeles, and every once in a while he'll sprinkle in actual characters. I'll be reading one of his books and I'm like, oh, that's an actual person. I know him. John Lewin came up in one of his books, who's also a DA and a friend of mine. And now they made it into a series on Netflix, and it's a really good series. It's really fun watch. It's really entertaining, and kudos to Netflix for bringing that series to life. So check those both out. Thank you, Katie, so much. Sarcasm loves Michael Connolly. I love him too. I'd love to meet the guy one day. Thank you, Katie, from Fort Smith, Arkansas, for bringing that up and giving us an opportunity to share that book with all of you. All right.
Hi to everyone on Courtroom Confidential. I'm a new viewer, enjoy it very much. My name is Mary from Jefferson City, Missouri, and my question has to do with genetic genealogy. For instance, with the JonBenét Ramsey case, it appears to me that if they simply do genetic genealogy on the known profile that they currently have in custody, it seems that they would be well on the way to discovering the identity of JonBenét's killer. What am I missing here? Thank you.
Thank you, Mary from Jefferson City, Missouri. We had a comment that made me laugh out loud not too long ago, where it said, Josh goes, all right, let's keep it moving as I try to keep the pace of this show, at a quick clip. And I say, let's keep it moving, followed by 15 minutes of tech wizardry on my part. I had to laugh because I do struggle to keep my small side of the tech side of all of this moving smoothly, but I've been practicing, and I hope you guys notice. Anyhow, Mary from Jefferson City, Missouri, let's put you on the map. Thank you so much for the question. Mary is asking a question about the JonBenét Ramsey case. We all knew, if you at all are a casual follower of true crime, you know about this case. Beautiful young girl. She was murdered in 1996. In December of 1996, she was only 6 years old at the time. This took place in Boulder, Colorado, and has gone unsolved ever since then. At one point, the parents were under suspicion. It doesn't seem as though the investigation is at all pointed in that direction now. But there has been one piece of evidence that people who continue to follow this case and want to solve it point towards, is that on JonBenét, there was some DNA that has only been described as unidentified male DNA. And they've never been able to match that to anyone. And it seems as though they've run into a roadblock, into a brick wall as far as what they can do with that DNA. Well, Mary says, what about IgG? What about investigative genetic genealogy? Can they do anything with that now? Because we hear about that being used so much. And if you guys are not familiar with that, that's the idea of using it to create a family tree, familial DNA. In other words, okay, maybe this DNA does not come back as a match to a person that's already in a database, but can we use it and put it into a system and find out relatives of this person? And then in creating relatives, can we kind of reverse engineer to figure out who our suspect might be? This was used in solving the Bryan Kohberger case. I don't want to say solved. It's still allegations. He hasn't been convicted. But in the Idaho 4 murders case, the reason they were able to target Bryan Kohberger as a suspect was through the use of IgG. A lot of controversies surrounding how they did that, but that's what they did. And it's an incredibly powerful tool. And Mary says, hey, why can't we do that here? We've got these advancements. Well, Mary, they heard you, because the latest news on this is that John Ramsey, the father, has asked for this to be done. He has made these suggestions. And CNN reported back in January of this year that the new police chief in Boulder, Chief Stephen Redfern, met with John Ramsey and discussed actually using new technologies, including IgG, for this unidentified male DNA. Now, we don't know where the status is of all of that. We don't know if that's been done. We don't know if that is currently under investigation. By the way, they're not going to tell us. They're not going to say we've identified a suspect. What we're going to hear, hopefully, is someone's been arrested, or a person who has since passed has been identified as the likely suspect. But it's a very good point. And I know you are not alone, Mary, in people saying, hey, we hear so much about DNA. Why aren't we able to use that in a case like this that has for so long gone unsolved, and people want justice for beautiful JonBenét? So that's the latest on that case, Mary. They are going to, my understanding, at least from this report, again, it's not like the Boulder Police Department is having press conferences about this, but they have said that they are going to use that DNA, and there's modern advancements that they're going to be able to employ upon that DNA. So we shall see. Stay tuned. That would be really, really remarkable stuff if that actually happens. Thank you so much, Mary from Jefferson City, Missouri. All right, let's keep it moving here.
Hello, Joshua. My name is Nishay, and I am in Philadelphia, Pennsylvania. My question is about disabilities such as autism, ADHD, and things like that. Also, hearing loss in potential jurors. I am autistic and have ADHD, and I know that jury duty would present some challenges as far as being able to focus and attentiveness and not having access to my devices and wanting to have fidget toys and stuff like that. But my next question is about like hearing aid users. Because my mom is a hearing aid user, and I know for a fact that it was a time when she was called for jury duty, and she actually intentionally did not wear her hearing aids, hoping that she would not be called. Is that something that, are sign language or ASL interpreters an option for jurors? I'm just wondering. Thanks so much. I love your show.
Thank you so much, Nishay from Philadelphia, Pennsylvania. Let's go ahead and put you up on the map. Thank you so much for being a listener and for leaving a question. And Nishay, if you're listening to this, you gotta give your mom a high five from me. That's very clever on her part for keeping her hearing aids out so that she presented some issues during jury selection. Talk about a clever way of getting out of jury duty. The answer, well, your question is how how are people with disabilities accommodated during jury duty? The answer is any and all accommodations that can be made will be made. I have seen this done with people who are disabled, wheelchair bound, or other accommodations need to be made. And I've seen this with people with all sorts of medical conditions as well. People who say, listen, I've got a medical condition where I have to go to the restroom quite frequently. The judge will accommodate that. I have a condition where I cannot, the lighting in here is too bright for me. I need to wear special glasses. Whatever it is, judges will make accommodations. Legally, no one can be prevented from doing their civic duty and serving on a jury if it has to do with some sort of disability. What usually ends up happening, though, is that many times, if it looks like this will cause some sort of undue burden to the person who is a prospective juror, and they're saying that could be a problem for them, usually both sides will stipulate to have that person dismissed so that they don't have to go through this, which might put them in an uncomfortable position for too long. But if you have a person who's like, listen, I have a disability with my hearing or my sight or my ability to, not a disability, but there are also people who are not native English speakers. And they're saying, listen, if you're going to get really technical, English is not my first language. I'm going to have a hard time keeping up. Accommodations will be made for those folks as well. But if the person is saying, I want to serve, I want to be on a jury, if you pick me, then accommodations will be made for that person. They're not just going to be dismissed because it might be difficult to accommodate them. So, Nishay, I think that's a wonderful question. I'm so glad that you're a listener, and I appreciate you asking that. All right, let's keep it going here.
Good day. It's Pretoria Girl from South Africa. In Pretoria, in the north of South Africa. True crime fanatic, also a true grizzly at heart. I would just like to know if you've ever listened to the tarot card readers and psychic investigators regarding a case. I am truly fascinated by that because for me, it's like turning to the end of the book and getting the answers before the court cases start. So that is really, really interesting. I take everything with a grain of salt, and I don't believe that has any other purpose other than entertainment purposes. But yeah, it's truly fascinating to hear what they have to say, especially in the Bryan Kohberger case. But yeah, love your program, love everyone speaking and listening to everything. Have a lovely day further.
Alonza, thank you so much for leaving this question. And I just realized I may have not heard correctly where it was you were from. I thought you said Victoria, and that is my fault. I think you may have said Pretoria. Doesn't matter. Kaylin's giving me big eyes. We've got South Africa on the map. You're putting South Africa on the map, and we appreciate that. But once I was listening to it again, I think that's what you might have said. Oh, everybody's correcting me now. Pretoria, Josh. Get it together. In any case, thank you for bringing us across the pond, Alonza. Thank you for being a Grizzly. Big fan of the Grizzlies on this show. Big supporters of our channel. We're big supporters of theirs. Gisela does incredible work. Oh, there she is. Pretoria. Oh, I had to embarrass myself in front of Gisela and get her own hometown wrong. Well, there you go. That's what I deserve for going through these things too quickly. Gisela, good morning. Well, it's not morning where you're at, but thank you so much for being here. And thank you, Alonza, for representing South Africa. Appreciate you all. I love this question. What are my thoughts on psychic investigators? It's funny. Tiffany, my wife, is much more accepting and open-minded when it comes to this kind of stuff. She reminds me all the time that we are both Scorpios and how remarkable that is. And whenever something strange happens, she also points out to me that that's because we're both Scorpios, and I give her a side eye kind of a look. And I have the same kind of thoughts on psychic investigators. I guess you could say I am healthy in my skepticism of it. But it was an interesting question, and I thought, you know what, I'll look into it. Am I on an island on this, or are there some police agencies who have used them? Here's the interesting thing I came up with. There have been some high profile cases where psychic investigators at least offered their services, though it was not successful in any kind of apprehension. The Chandra Levy case was one that I came across. The Elizabeth Smart case. Usually it's in cases where somebody is missing and they need help finding that person. Sometimes psychic investigators are either employed, not usually by the police department, but by someone else, or they offer their services. Here's the issue with that, is that in these high profile cases, especially missing person cases, the police are oftentimes asking for help and welcoming the public to provide tips, because they've kind of reached the end of what they can do and they need the help. They will get thousands of tips. They're flooded with tips in these types of cases. And they have to go through each one of those tips. And they sometimes employ massive amounts of overtime with other investigators just to go through these tips. And if a lot of those tips are psychic investigators and not all that helpful, you could see some of the problems that might present. And in my research, I did come across this statistic, and I don't know if it's true. And if you guys know of an exception, please let me know. But that apparently in the United States, no police agency has ever credited a psychic detective with offering information that helps solve a case. So not the entirely highest of success rates, but thank you so much, Alonza from Pretoria, South Africa. I promise not to get it wrong again. And I appreciate all of our South African supporters for calling in. All right. I guess I'm not perfect. This is not my fault. This is the internet's fault.
Hi, Josh and community. This is Andrea from Columbia Falls, Montana, just outside the Crown of the Continent Glacier National Park. My question has to do with hearsay. So I understand how and why the police body cam video of Charles Vallow pleading for his life, talking about how Lori had threatened to end him, was not allowed into court due to being hearsay, as he was deceased at the time. So I understand the point has been hashed and rehashed and mashed to a pulp. So understand why it's not allowed. So my question is, if someone is in that kind of a situation, is there anything that they can do to document their belief that this particular person means to harm them, that will be allowed in as evidence if something does indeed happen to them and they are deceased? I don't know if that makes sense. So is there any way to make that of evidentiary value in case someone is in that situation? Rest assured, I am not. I'm just curious about it. Thank you so much.
Andrea, thank you so much for the question. I understand your question and I understand where it's coming from, and I appreciate you telling us that we don't need to worry about you. Andrea is calling from Columbia Falls, Montana. So let's go ahead and put that on the map first of all. This is Andrea's question, and it's a great one because I understand the frustration that a lot of people had in regards to what happened in the recent Lori Vallow case for the murder of her husband, Charles Vallow. But there was video footage, and we all saw this. It was badge cam footage of Charles talking to police about how his wife had been threatening him. And this is outside of the Homer apartment where they were living at the time. And he's trying to get the police to do something about that. And you can tell he's kind of frustrated. And he's saying, well, she's threatened me before. And, he's asking for help. And the part that was frustrating beyond watching a man who soon was killed and now by his own wife, convicted of that, there was also, why wasn't this able to be used at her trial? And that frustrated a lot of people because it's like, this is valuable information. Why can't we hear from this? And we talked a lot about hearsay. And Andrea is saying, I understand why it's hearsay. It's hearsay because it's an out-of-court statement. It was a statement made by Charles Vallow when he's out of court. And it was being offered for the truth of the matter asserted, meaning the only reason we're hearing from him is if we want to believe that he is saying he has been threatened by Lori Vallow. We talked about, well, first of all, you've got one level of hearsay from Lori to Charles. Then you've got another level of hearsay from Charles to the police officer. And then because Charles is unavailable to testify, he's not going to be able to be cross-examined, and therefore they're not going to get this information in. And Andrea says, well, that scares me. What can someone do? Great question. First of all, if anyone is ever in this kind of fear, go to the police immediately. I mean, that's, full stop. And going to the police, not just because you're in fear, but it does memorialize things, and they do create police reports. And there is a trail of this, and there may be some way to get this introduced at trial. Certainly, if the defendant were to take the stand, now you have a bunch of impeachable statements that you can bring up to that person. But short of that, what can be done? This is a part of the law that can appear to be frustrating if you don't entirely understand the reasons for it, being all about cross-examination and the constitutional right of the defendant to confront and cross-examine all who make accusations against them. And if that person's not available and there's not some hearsay exception, then it can't be brought in. Now, we've talked about dying declarations, and that didn't apply here because he wasn't under the immediate belief that he was going to die. He was describing something that took place in the past, so it's not a current sense impression, is sometimes an exception. My advice is keep a diary if somebody is going through something like this, and not only talking to the police, but keep a diary, keep it in a safe place, because there is an argument that this could amount to another hearsay exception, which is called a then existing mental, emotional, or physical condition. In other words, it's not hearsay when somebody says, I'm scared, or I'm sick, or after I ate that sandwich provided to me by my wife, I felt ill. You are describing your then existing mental, emotional, or physical condition. What could be hearsay is, I believe my wife is trying to kill me. But memorializing to either police or in a diary, I'm under fear. I ate a sandwich and I felt bad. Here's all the things that happened to me and how it made me either feel mentally, emotionally, or physically. There is an argument that could be introduced at trial, even if the speaker, the one keeping the diary, was unavailable because they were killed. Yes, all those comments could be made to other people and perhaps admissible that way, but I think there might be even stronger arguments for somebody who had kept a diary. I realize I'm giving really kind of dark advice here, and obviously I hope no one is experiencing something like this, but if you are, go to the police, and if you're not, go ahead and keep a diary anyways, because you never know when it might be helpful to you. But Andrea from Columbia Falls, thank you so much for the wonderful question. That was a kind of twist on something that we had talked about before. Oh, the Sarge is in the house. True Crime with the Sarge. Joe Jackalone says, I think I've said that a number of times in the past about keeping a diary. Really grim stuff. I don't keep a diary. Maybe I should start. Tiffany's been giving me some side eye looks lately, and maybe I should keep a diary just in case. Thank you so much. The Sarge, by the way, we interviewed him recently, and I'm going to be talking to him on Tuesday. So we were going to talk about that in our announcements later on. But don't miss out. The Sarge is going to grill me under the hot lights this coming Tuesday. And good to see you, my friend. That was a wonderful conversation that we had. And thank you, Janet, for becoming a brand new YouTube member. Appreciate you and appreciate your support. All right, let's keep it going here.
Hi, this is Gloria from Florida. I just had a question about the Karen Reed trial and the connection with the federal government investigation. Will we ever know why the federal government was investigating the Karen Reed case? It was evidently a gift to the defense that the ARCA investigators released their report. But in the first trial, we heard about it, but some of the jurors didn't know who ARCA was and thought maybe it was something to do with her car insurance. Well, that didn't help. They haven't been on the stand yet in the second trial that's coming up for the next week or so. But I just wonder, will we ever find out why the federal government was involved? Was it because it was an investigation of a police department, and then for that very reason, maybe that implies that there was something going on with the police investigation, which there was a lot of holes in the police investigation. So I just wondered if that's ever going to be found out. Okay, thank you.
Thank you, Gloria from Florida. Let's put you up on the map, and thank you, the Sarge, for all the support for our Sunday Fun Day. And great question, Gloria. Gloria asked about the federal investigation that was done in the Karen Reed case. And are we ever going to get to the bottom of why that was done? And how about what conclusions they arrived at? What findings, what evidence was there either uncovered or not? Great question that a lot of people have been wondering about. And just to give you all some background on this, before even the first trial began, there was the Department of Justice had opened an investigation into the Karen Reed investigation. And that's about all we knew about it. The Department of Justice made no official announcements about this. This was all information shared through the court in the Karen Reed case through the defense attorneys. It was the reason why ARCA got involved. ARCA was hired by the feds, and the defense says, well, we want to use them. They've created a report. They've got findings. We didn't hire them. They are objective, and we would like to use them in our case. And it had I think, arguably some great effect for the defense in the first trial, and we'll see how that works out the second trial. They're about to start their case in chief, by the way, or they have started their case in chief, and I'm sure ARCA will probably be coming up this week. And first of all, we were never informed as to why the investigation was started, how it got started. We have some unconfirmed rumors. We believe that maybe it was done upon the defense request, that maybe they had reached out to the Department of Justice, said, you need to look into this. There's a lot of shenanigans and shadery that you guys need to investigate. So it was believed that they may have been investigating allegations of misconduct, but they never explained that. And by the way, they're never going to. The federal government investigates things all the time, and they're never going to explain why they investigate these things. And they're never going to reveal the findings of their investigation unless that leads to charges, unless you end up in the business end of an indictment. Will they ever release what those investigations are done? This, I'm not going to say is common, but it does happen where the feds will look into something, investigate something, perhaps hand off the case to a state agency, or perhaps just use it for their own purposes. June, you are so fantastic. Thank you so much for the gift of memberships. What we do know is that it has ended. Hank Brennan the special prosecutor in this case announced in March, quote, "There is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters," adding, "It is closed, it is over." Not saying what findings have been made, not saying what conclusions were drawn, not saying anything beyond they investigated and it led to nothing. Now, Gloria makes, not part of your question, but as an interesting aside, kind of outlines why this will never be explained to the jurors. And I know a lot of people go, well, why didn't they tell the jurors that ARCA came from a federal investigation? Gloria, in your comments, said it implied that something was going on if the feds were investigating. And that is exactly the fear that the court has. The implication that could be drawn from this is inappropriate. The implication that because the feds are looking into something, therefore something shady took place, is exactly what they're trying to avoid. And that's why it was never explained to the jurors where ARCA came from. And it was just described as an independent third party. Now, I know this time around, there has been some slips on all of that, and the jury may be aware of all of it. But the whole point is, like, listen, we're not going to allow jurors to draw a conclusion or an implication from something that hasn't been declared officially by that investigating agency. Think about the other side of it. Now that it has been ended, would we want the statement to be made in court that the investigators in Karen Reed's matter, the state investigators, have been cleared of any kind of wrongdoing? And what kind of implication could be drawn from that? That therefore, what is that? Some sort of a stamp of approval for the prosecution of Karen Reed? That is something we absolutely would not want the jurors draw implications we would want them drawing from the fact that they ended the federal investigation. So all the jurors are ever going to know, and all that we will probably ever know, is that an investigation was opened for whatever reason, and that investigation has since been closed, and there was nothing done with all of it. So great question, Gloria. Arizona Gal 89 says, thank you so much. Gisela K and Josh Ritter logged in at the same time and on the same channel. Winning. Love you both. Thank you so much, Arizona Gal. Thank you, Gisela, for stopping by. I always appreciate it, and I always appreciate the love from everybody and your support. Best Gun Losing Detective says, I don't believe it is closed. The feds tell us nothing, and another arrest has been made. Well, I don't know if it's been closed. The feds aren't telling us, and they haven't called me personally, but they did apparently either let the prosecution's office know or let Brennan know enough that he was able to say in open court on the record, there is no longer a federal investigation. So whether that means it's been closed or they've shifted the investigation to other matters in Massachusetts, we don't know. All we know is that as far as Karen Reed's or the investigation, quote unquote, into the investigation of John O'Keefe's death or any related matters, that has been closed. So great questions, everybody. Appreciate the super chats and all the support. Whew. All right, here we go. That was Gloria. Now we're on to the next here.
Hey, Josh, Derek here in Santa Barbara. Love your fantastic show. You're becoming the GOAT of true crime shows. Seriously, greatest of all time. On the way. You made a great comment last Sunday, today, which is today. I'm following up after that show today about judges be crazy, and that's such great insight. And I'd love to hear your comments about Beverly Cannone. She's not only crazy, but she's corrupt. She's pushing this whole thing in the direction to favor the prosecution in every way. That was the case in the first trial, and it's the case in the second trial. And some of her decisions are just mystifying, you know, not allowing ARCA, how ARCA came into the picture as accident reconstruction, where they were originally hired by the FBI, not even allowing that to be discussed by the defense. She's done so many things. disregarding the dog bite expert that the defense provided in the earlier trial. They haven't even provided their defense yet, so we'll see what happens here. But if you could talk about Beverly Cannone, I'd appreciate it. She'd be crazy. Thanks a lot, Josh. Take care.
Of all of my in-depth legal analysis, Judges Be Crazy is the standout so far. Thank you so much, Derek. June, thank you again. I didn't realize that was 10 memberships, so that is incredibly generous of you. Appreciate all your support. Seeking Justice, thank you for your support, and thank you for just being here and asking questions. All right. Derek, you're fantastic. I appreciate the kind words. Calling from Santa Barbara, California. Love Santa Barbara. I'm totally blanking on the name of one of my favorite restaurants there that's on the dock, on the pier. You can look out over the water and have yourself a nice clam chowder. I'll remember it later, Derek. Maybe you can tell me if you're watching, if you're with us this morning. But you ask about Karen Reed and everybody's favorite judge to throw tomatoes at, Judge Beverly Cannone. And what are my thoughts on Judge Beverly Cannone? I'm probably not going to tell you what you want to hear, Derek. I am not as bothered by Judge Cannone as most people are. I think it's a matter of I've seen and dealt with and had so many awful judges preside over me in trials that I've handled. The Beverly Cannone would honestly not make my top 10, but I get it. I get the outrage, and I get people's response to her. P. Lola's mom, thank you so much joining support of the CC train. I appreciate it. Let's keep it running. I get it. Here's the thing. I actually think she is. Every judge is going to have to make decisions. And with every decision that's made, you're going to piss off one side or the other. I feel like she has been reasonably fair in her decisions that she's made on this case. Derek, you bring up the point about ARCA, not allowing evidence of ARCA to have been hired by the feds. I did not line up these questions together, but it is amazing how they really do relate to each other. Our last question from Gloria. The reason she did that was appropriate because we don't want the jurors drawing the conclusion that because ARCA was hired by the feds, therefore the prosecuting agency is under investigation by the feds. And it's like, oh my God, all the inappropriate conclusions they could draw from that. We already saw that they tried to draw inappropriate conclusions and that they thought it might have been her insurance company. So you can see how hard it is to herd the 12 cats that are the jurors. Okay. The other reason that we didn't talk about ARCA, not to repeat myself from the last question, is that we don't want them knowing if they ended their investigation. I certainly, if you are a supporter of Karen Reed, would not want the jurors knowing that the federal investigation has been ended with no indictments. That's some inappropriate conclusions they could draw from that. But I will say too, I thought that and this is probably I can already hear everybody sharpening up their pitchforks, but I do feel that a lot of judges, you remember the findings she made regarding the communications that had taken place between ARCA and the defense, and some which she felt was violations of discovery rules in the turning over of certain things from the defense to the prosecution, and the deleting of emails and the using of Signal and everything else. And she allowed ARCA, and she said, I'm not going to keep you from having ARCA. I'm not going to prevent that from happening. I'm going to allow for, her quote unquote robust cross-examination by the prosecution. But I will tell you, there are judges out there who would have kicked that expert out, would have kicked ARCA out, would have said, I'm not allowing it. You violated. I found that you have violated discovery obligations, and I have found that you have not been forthcoming with this court. I am not saying that's my belief. I'm saying that's the judge's beliefs, and I could see a lot of judges not have doing what she did, but she felt I am not going to completely throw a hand grenade in the middle of the defense case. Is that her being fair? Is that her throwing the defense a bone? I'll let you guys all be the judge of that. I am not. I understand the ire against her. I just am not as. I don't set my hair on fire as much about it, but I get it, Derek, and I appreciate all your kind words. And I hope you ask another question and don't turn off this channel forever. But thank you so much. All right, let us keep it going here.
Hello, everybody at Courtroom Confidential. This is Holly in Houston, and I have two questions after having watched Gizla's Sunday live stream titled Betrayal and Justice, the Dorris Worrell Cold Case Breakthrough. So I won't tell all the details. I couldn't possibly, because it is a deep dive. I'm about to do my homework that Gizla has signed with more resources after this, actually. Because I have to know more. There's more. It's a very recent arrest that has occurred in this case. Now, my first question regards the nanny. She covered that the nanny essentially told law enforcement that she knew more than she was going to tell them. I thought withholding information is not okay. Am I wrong on that? I mean, after that, she went free. She left the country. She went on about her life. Yah. I'm like, I don't even know. So that's one. For two, let's say when a suspect says, well, I will only, or person of interest says, I will only speak with an attorney present. Either one, suspect, person of interest, whatever the proper thing is. As a defense attorney, how do you gauge what your client is allowed to answer to and what they can't answer to? Yeah, so that's it. Thanks, guys.
Holly from Houston. Always love hearing from you, Holly. Thank you so much for calling and leaving the question. Let's put Houston on the map. First of all, is Gizla still in the chat? I hope she is. This was such a great shout out to her. Gizla just doing the best of the deep dive work over there at Grizzly True Crime. This is an incredible episode that she did. We're going to include the link for it. It was called Betrayal and Justice, the Dorris Worrell Cold Case Breakthrough. The husband was just arrested. If you have not watched it and you are interested in this case, you know what? Even if you're not interested in this case, go watch this episode. She did an incredible job. And do me a favor and just leave her a little comment saying Courtroom Confidential sent you over there. I love to tell her that we do our best to support her as well. Here is what happened in this case. John Worrell, the gentleman in the middle there, was married to Dorris Worrell, the lady on the right, had 3 children with her, but then they get a nanny, Paola Yarberry, who's on the left there. She was 18 years old at the time. 18. And he starts an affair with her. Dorris gets shot and killed. And police at the time believe that it was a tragic case of perhaps a murder going wrong. By the way, this is in September of 2006. So we're going on 20 years ago. They believe it might have been a robbery gone wrong. They believe that it may have been an angry patron that John had kicked out of their business earlier. And he is not investigated initially. But then the police start to realize that there was trouble in paradise between John and Dorris, and that he had actually, their theory was, been seeking a divorce, but didn't want to get one because he thought he would lose custody of his 3 children. So, like most psychopaths do, decides to go out and plan and kill her. There were also some other suspects that they believe may have been involved in the actual shooting, not John himself. Anyhow, they don't file against John because they don't have enough evidence. And John and the nanny, Paola, then moved to Costa Rica with the 3 kids, and they've been there for the past 20 years, living lives together. Well, the investigators, and you got to applaud them, are tenacious and never forget. And they realize that John and Paola split up, and she might now be in a different mood to go ahead and speak with them. So they go down to Costa Rica, they interview her, and based upon the information that they hand over to her, they have now arrested John Worrell for the murder of his wife. He's being extradited back to Georgia. This took place in Douglas, Georgia, and he's going to be tried for her murder. Fascinating case. Case that we're going to probably be following more closely here on this channel, but check out Gizla's coverage of this. Now, Holly's question, though, is initially part of the reason that Paola had to leave the country is because she was not cooperating with police in giving them information. She was withholding information. And Holly asked, well, isn't that wrong? Isn't that something you can't do, withhold information from police? First of all, federally, that is true. There is a federal statute that makes lying to law enforcement illegal. Anyone has a Fifth Amendment right to not speak. You do not have to speak with law enforcement. You can say, I have a Fifth Amendment right, and not speak to law enforcement. But in federal cases, lying to the FBI can be charged as a crime itself. That does not apply on the state level. You can lie to police detectives all day long and never be charged with it. And you can withhold information, and you can refuse to speak with them. None of that applies on the state level. So she was not in trouble for withholding information on the state level. What got her into trouble was her immigration status. And because if you're here on any kind of a visa, you do not enjoy the same, you do have constitutional rights, but they are not applied in the same way. And refusing to cooperate with law enforcement can be a reason to have your visa revoked. It's not deportation. It's just revocation of your work visa. So that's what's happened with her. And that's why it was a little bit different with the application of Paola's case. And then separate and aside from that, and kind of connected to this, Holly asks, how do you decide what your client can answer and cannot answer? The answer to that is you are never going to have your client speak with law enforcement unless they are willing to tell them everything. In other words, the vast majority of cases never feel that it is a benefit for my client to speak with law enforcement. If some sort of information needs to be shared with law enforcement, that can be done through me. But actually having my client sit down with law enforcement and do an interview with me sitting there, not going to happen. But if it does happen, we've talked about it and I prepared them ahead of time that they got to tell them anything. They're not going to stop this interview in the middle of it because that's going to be a problem. And they're not going to lie to them because that's going to be a bigger problem. And they're not going to withhold information because that's going to be a problem too. Here's the legal ramifications of all of it, though. Everybody has a Fifth Amendment right not to speak to police. And if in the course of your interview, you invoke your Fifth Amendment right in the middle of it, that cannot be used against you. The invocation of your Fifth Amendment right can never be brought up in court. That is a huge error. That is mistrial, even sanctions against the police or prosecutors for ever commenting on somebody's Fifth Amendment invocation of their rights. Immediately would end that trial. So even if the person is speaking with police, and even if police bring up part of that interview, if the person midway through says, I'm done talking, I want my lawyer, I'm invoking my Fifth, that cannot be commented on. And you cannot even allude to the fact that the interview was not concluded. The caveat and exception to that is if a person is not invoking their rights, but they're being evasive, or they're they're choosing which questions they're choosing to answer. So in other words, somebody's waived their rights, says I'll speak to the police, and then when the police start asking them questions related directly to the crime they're investigating, they go, I don't want to talk about that. That can be commented on. That's different than an invocation of your Fifth Amendment right. And that's why you don't talk to the police unless you're willing to tell them everything. And that's why you don't, you go in there with your attorney to make sure that you don't run into these issues, because that could be a major problem if you got a detective on the stand saying, and what did they say about their whereabouts at the time of the killing? They said they didn't want to talk about that. That's a big problem. Anyhow, Holly, you asked the bestest of questions always, and I appreciate that. Check out Gizla's video on all of this, everybody. That's your homework from me. All right. Let's keep it moving.
Hello, Josh. This is Carmina from Valencia in Spain. And last week I told you about the Murder by the Coast documentary. So I thought I could tell you about another case that happened here in 2013. Yeah, it's a very famous case, really sad. And you don't need to watch the documentary or the miniseries if they are too long. But I thought maybe the listeners could be interested in the case. So, yeah, it is about Asunta Basterra's death. She was a 12-year-old girl who was murdered in La Coruña, Galicia. This is in the north of Spain. And yeah, I'm not gonna give many details because I don't know if they want to watch the documentary or the miniseries. So I leave that to you. But yeah, it's a very interesting case, and the TV show is called The Asunta Case. It has 6 episodes from last year on Netflix. And well, I just want to point out that if you don't speak Spanish, the show is available in different languages like English, but have in mind that these actors got awards for these roles, and I think that a big part of the performance is how they imitate, in a way, the original people involved in the case, and the accent, you know, the way they speak in Galicia is a big part of that performance. So if you don't mind reading subtitles, I would strongly recommend to watch it in the original version. And finally, you have a documentary of 3 episodes called El Caso Asunta, Operación Nenúfar. You can also find it by the Asunta Case. And it's from 2017. And this is in Spanish with English subtitles. And yeah, that's all. I hope somebody will find it interesting. Yeah, have a good day.
Thank you so much, Carmina from Valencia, Spain. Always love hearing from you and always love the recommendations that you have. You gave me a really great recommendation last time, and I watched that series. I did not watch this case. So first of all, let's put you on the map from Valencia, Spain. And thank you for the recommendation. And I promise you, I will make the time to watch this one because it does sound like a fascinating case. But Carmina is referencing 2 series that can be found on Netflix. The first is called The Asunta Case, and the other kind of sister, oh, there you are. The other sister on the ground joining us. The other sister documentary is called, I'm going to butcher this. I love that you're here to hear me butcher this. El Caso Asunta, Operación Nenúfar, which translates to Operation Water Lily, which I thought was interesting. And I don't know the reference to that in the case, but I will try to watch them. I think one of them, by the way, is not available in the US, but I think the Asunta Case is. Anyhow, here's a quick summary of what the case is about. So if you guys are interested in watching this, Asunta Yongfeng Basterra Porto was a Chinese-born Spanish girl whose body was found in Galicia, Spain in September of 2013, shortly just before her 13th birthday. Young, beautiful girl that we see there. The coroner determined that she had died by asphyxiation and had been given at least 27 lorazepam pills on the day of her death. That is 9 times what is the highest dose for an adult. Lorazepam, if you don't know, is a very strong sedative. Asunta's adoptive parents, Rosario Porto and Alfonso Bastera, were found guilty of her murder in October of 2015. And according to the documents, according to court documents, they would regularly and periodically drug her with lorazepam for at least 3 months leading up to finally her death when she was asphyxiated. Horrific type stuff. I want to watch the series. They were sentenced to 18 years in prison. Porto actually took his own life. She took her own life in November. Anyhow, thank you so much for that recommendation, Carmina, especially about cases taking place outside the U.S. I love this kind of stuff to hear about the true crime world and how it's covered in other countries. And this is probably not something I would have clicked on, but I'm going to do that now. That Netflix series out of 2024 especially looks very good. So thank you for that. Carmina June says, oh, you got a question here. Here we go. I came in with a Disabilities Act question. I was wondering about people with service dogs. Yes, you have service dogs. You're allowed them in court. In fact, when I was working downtown as a DA, there was a courtroom translator, a English to Spanish translator who was blind and had a seeing eye dog with her. And we all loved this dog, the most well-behaved dog in the world. And she would bring the dog into court. And so she would walk into court with her seeing eye dog and translate for whatever case was going on. And the dog would sit there so patiently and take little naps during trial. And it was a treat for all of us to have a little fur baby in court with all of us. But yes, any kind of accommodation will be made in courts. Great question. Oh, best gun losing detective says, I just realized now that name. Sorry, I would use Signal. Your lead investigator. Oh, I get it. Sorry, I would use Signal. Your lead investigator was looking for nudes and special prosecutor tried to pierce privilege. Yeah, I get it. Here's the problem, though. It don't look all that great, right? If your communications with your expert, shouldn't ever be a problem. I mean, I get what you're saying. You would be a little paranoid about how, whether or not these communications would be coming out. But the judge's point is you shouldn't be paranoid about these communications because there should be nothing wrong with them. And they're going to be turned over anyways. And that's the whole problem. You're supposed to turn these things over. And if you're putting them in a format that can't be turned over, it's going to raise the proverbial eyebrow or two. But great question. Best gun losing detective. Brophy's. Yes. Love that place. Thank you, Derek. Thank you for reminding me. Tiffany, take me to Brophy's. Isn't Father's Day coming up? I want to go to Brophy's. All right, let's keep it moving here.
Hi, Josh. It's Lynette again from Exeter in England. Now I know it works. I've got another question. It's all trials, really. If you've got prosecution or defense asking questions of a witness and it's objected to and sustained by the judge, and this goes back and forth, or the judge will suddenly say it differently or ask it in a different way, what exactly can you and can you not say? Because the question is exactly the same and the answer's the same. It's just a few different words, and it just drives me mad. And yeah, I'd appreciate if you could explain what you're allowed to say. Many thanks. Cheers, guys. Bye.
Thank you so much, Lynette from Exeter, England. Let's put you on the map. I appreciate you calling in. I share in your frustration. And in fact, sometimes I'll even hear a judge say, ask it differently, and they will ask it the same way. They will just emphasize other words more than others. It'll be like, wasn't it, did you go from the crime scene to the station? Ask it differently. Did you go from the crime scene to the station? I mean, it was just like, it's like sometimes it is pretty comical how this stuff will work out in court. But for the most part, this is a great question, Lynette. For the most part, what is happening is the judge is signaling, and we see this come up in the Karen Reed case quite a bit because the judge won't allow for grounds. Otherwise, a lot of this would become clear. But because the attorneys and the judge speak this language and they all kind of understand what the objection is likely about, when a judge is saying, ask it differently, what she's saying is, one, I'm sustaining the objection, but two, the evidence being elicited is not improper. It's just the form of the question is the problem. In other words, there are different objections that you can make to form as opposed to the answer itself is eliciting improper evidence. So a leading question is a form problem. A question that assumes facts not in evidence. A question that is compound. A question that is vague. All of those are form objections. All of those are eliciting proper evidence, but you're just asking it the wrong way. So that's why the judge is saying, ask it differently. In other words, she is sustaining the objection as to form, but allowing for the inquiry into the ultimate evidence being asked. That is different from objections dealing with the evidence being improper. Hearsay. In other words, a judge is not going to say it differently when you're eliciting hearsay or irrelevant evidence or evidence based upon prior rulings as being something that you can't get into. So that's what's going on. The say it differently is just change the form of it. I'm not really all that concerned about the answer that's going to be given, but you just got to get there the right way. Great question though, Lynette. We see that come up quite a bit, and I laugh the same as you do because it seems like they don't ever change it anyways. And hello to our friends over there in the UK. All right, let's keep it going here.
Hey, Josh, this is Holly from St. Louis, Missouri. I have two questions. First question. It seems the majority of your listeners/callers are women. Do you agree? If you do, can you speculate on why that might be? Second question. Say I commit a murder and I'm lucky enough to get a great attorney. When I first meet that attorney, do I tell him or her everything or just be quiet while they ask me specific questions they want to know the answers to? Does the attorney want to know the details or would that compromise them in any way? Thank you.
Great questions, Holly. Thank you so much. Holly from St. Louis, Missouri. Why are the majority of your subscribers women? I have noticed that. And there's a reason for that. It's because the majority of true crime listeners are women, and they actually have done research on this. There is a Pew Research report out on all of this that goes through. They went and did a survey of regular podcast listeners. Podcast, I think we could probably say, is a good Alicia K. Mayo says Josh is simply brilliant. Well, thank you. The podcast, I think, is a good translation for YouTube, consumers of true crime. And what they found is, of people who regularly listen to podcasts, 34% regularly listen to true crime. So true crime is just a very popular part. I mean, a third of podcast listeners are listening to true crime. So it's very popular part of the podcasting, YouTubing world to begin with. And of those regular podcast listeners, 44% of women listen to true crime as opposed to 23% of men. So nearly twice as much women who actively listen to podcasts are listening to true crime over men. Some other interesting stuff I found in that report is that the percentages broken down by age are 41% are between the ages of 18 and 29, 35% between the ages of 30 and 49, 33% between the ages of 50 and 64, and 15% between over the age of 65. So just really interesting analysis that they've done with all of that. One last thing on this. Of the top ranked podcasts in the world, 24% are in true crime. So it's a very, very popular genre in podcasting and YouTubing and everything else. I thought all of this was really fascinating. So I wanted to share that with you because anecdotally, I've noticed the same thing. Even when you go to CrimeCon, you kind of notice that it's a very female dominated audience. Now, Holly says, why is that? That is a more interesting question. And I tried to look into that and do some research. And I've talked to other creators about that. And people have theories. People have, I think actually, who was it? I think it was Linda from It's a Crime. We talked a little bit about that. And she said that she feels it has to do with kind of, there's a, I don't know, I hope I'm going to put this diplomatically enough, that there's a female fear of the horrible things that could take place to you, and that watching it kind of helps you psychologically deal with it. I don't know if that's true or not. I know I love watching true crime, and it's mainly because I kind of like the mystery and the solving of it, and the kind of, I guess I'm a little bit sick too, just the kind of understanding of human depravity sometimes. But I didn't find anything that gave me a great answer. And I thought I'd open it up to you guys. Tell us, why is it that you are drawn to true crime? I think that's a great poll that maybe we should do. But while we're sitting here, let us know, give me a comment. Why is it that you're drawn to this genre that is kind of not bizarre, but it is a unique thing to be interested in it. Women always want to be prepared. Yeah, that's kind of the point. Jen Pokey points out, women want to know, my wife has all sorts of contingency plans for if we hear a bump in the night. Afton says, I like it because I'm a storyteller. I'm learning new things about people. I love that. I think that's a great point too. It's that human drama, that human experience. And just knowing kind of the lengths that people will go to. The mystery. I used to love Nancy Drew as a kid, says Britt Black. A lot of different reasons, and I don't know if anyone can be pigeonholed into one of them, but it is interesting that it does seem to be so very heavily female dominated. I don't want to become a victim, says my cat's name is Karen. Great stuff, guys. And Martha Ivy says, I like to learn about the law. See, I mean, we just got 6 different answers from 6 different people. I don't know if there's any real conclusion on all of that. And then, Holly, you ask a question that is near and dear to me. If you are in trouble, because Holly has taken all the notes that she's taken from watching true crime and decided to go out and commit a horrific murder, and now she's got an attorney, what is she going to do? Is she going to tell her attorney everything? Yes. Tell your attorney everything. I don't get attorneys who say, I don't care, or I don't need to know. I need to know everything. Here's the problem. By the time you've hired me, you've probably been arrested, indicted, or are about to be, and I'm already behind the 8 ball. It does not help me to not have as much information as I can possibly get. And I will tell clients this all the time. This is a judgment-free zone. I need to know. This is I'm the one person on earth you can tell everything to. We have a legal protection. You have privilege. Tell me everything so that I can possibly help you. Help me help you. And if you're not telling me everything, I can't help you. I can tell you how often that does not take place and how it always comes back to burn me. Always, my client will not share with me everything. They will give me the rosy version of what took place. They will give me the G-rated version. They will sprinkle a little healthy tasting of I don't need to tell my lawyer everything on top of it, and then I'm just burned because the prosecutor knows, or there's information that comes out, or I say something stupid in court that's proven wrong and my client knew it all the time. Simi Sharp says, Josh, quote, if you're guilty, you need a lawyer. If you're innocent, you really need a lawyer. That's 100% true. Yeah, so tell your lawyer everything, because there's no one else you can share this information with, and they need to know everything. I cannot figure out how to defend you if you're not even being straight with me. And it does help when you do know, listen, I've had clients tell me some pretty horrific stuff, and then we can go, okay, well, there are certain arguments we can and cannot make now. Now I know perhaps what plea negotiation to try to pursue for you. But if you're just giving me this, and also, by the way, do you really want to start off on that foot with your lawyer? I mean, do you really want to not, be building this relationship with your lawyer that is not entirely based upon honesty? Just some food for thought. Thank you so much, Holly, for the wonderful questions from St. Louis, Missouri. Appreciate you. All right.
Hello, this is Madeline calling from Denver, as always. I have not been watching a lot of the most current trials because I'm just kind of tired and annoyed with them. But I've seen a lot of clips, and it brought up a question that I've had for a long time. How do you handle new experts? Like expert witnesses, these people who've testified like 100 times, like they had to have started somewhere. But it seems like oftentimes attorneys will use the inexperience of somebody to say that to discredit that person. Like, you're only testifying for the third time. Like, can we trust your knowledge? And all of that. So, like, how do you build credibility for an expert? Or are these people who are currently being testifying as experts just like going to be that person forever? I don't know. We all start somewhere. So I'm just curious how it works with expert witnesses in a courtroom setting. Thank you. Bye.
Thank you so much, Madeline from Denver, Colorado. Always love to hear from you. Analytical Blarney AB, thank you so much for the question. Says, it helps keep perspective on my own life. When I think life is rough, hearing from the victims makes my life not seem so stressful in those moments. There's another great reason for somebody to be into this world. All of those reasons, I think we all kind of share to varying degrees too. Yeah, it is true. You watch some of the stuff, some of the horrible loss that people have experienced, and it really makes the fact that you had a hard time finding a parking spot take on a new perspective. So thank you for that. Madeline, your question is a good one, because what do you do about these experts that don't have all this experience? And how does an expert start to get that experience if they don't have to start off somewhere? And the answer is, usually an expert is not going to have a bunch of trouble just based upon the idea that they've never testified before. They're going to get more trouble if they just have a lack of experience in their field. But if you are an incredibly qualified person in your field and you've got the educational, bona fides to back it all up, and you've got the casework and the experience and everything else, the fact that you have not testified all that much is something that's going to be brought up on cross-examination, but is not going to disqualify you, certainly, from being an expert, and will likely not disqualify you from being considered by the jury. But it is funny, to your point, though, most experts who testify have been experts dozens, if not hundreds of times in some of these cases, certainly when they're a certain type of expert. One, and this was a very kind of en vogue thing for a long time, and I think it's still used, but it did seem like this was something we would see on nearly every case, was there was a lot of experts on eyewitness identifications, psychologists talking about how bad eyewitness identifications are, and the idea of weapons focus, that if you got a gun pointed in your face, you're paying attention to the gun, you're not paying attention to the face of the person who's pointing that gun at you, and how memories change and memories can be affected, and cross-racial identification, what role that all plays. And we used to, when I was a prosecutor, it was nearly every case that involved eyewitness identification, you were going to be hearing from an eyewitness identification expert. And they had testified dozens and dozens and dozens and dozens of times. And yes, that was helpful to the extent that they had the expertise of having testified, but it was also helpful for cross-examination in that we had all those transcripts to go back on. And when I was in the DA's office, we would pass these things around. Oh, so-and-so did a really fantastic cross-examination of this expert. I'll send you the transcript. And we would, we would sit down and basically come up with a blueprint for how to cross-examine, cross-examinate is not a word, cross-examine these people based upon how they had been cross-examined before, and to great effect. And by the way, pointing out, maybe where they had been found to be wrong, or maybe misconduct, all of this stuff, you testify enough, you're going to create a good and bad track record. And there were people that this was nearly their income was testifying as experts and expert fees. So that is how all of that is handled. Madeline, great question. And thank you so much for calling in from Denver and asking that wonderful question. All right. Let's keep it moving here. Kale says, can you get Melanie Little for a Wednesday Karen Reed? I think we will absolutely do that, Kale. Wonderful suggestion. And thank you for leaving the comment.
Hello, Courtroom Confidential crew. This is CB Kansas calling from Kansas City, Missouri again. First of all, I want to say thank you to the Ritter family for producing a great show, and the only show that I am a member of. Anyway, to get to my question. Josh, as a defense attorney or as a prosecutor, have you ever used a mock jury? If so, how did it work out? Did you think that it helped or hurt? Second, if not, then why not? What are the cons to using a mock jury? That's all. Thanks. Bye.
Thank you so much, CB Kansas. What a nice thing. I'm very, very flattered and touched by the fact that we are your sole membership, and I appreciate you asking the question, and I appreciate you bringing up a really interesting topic about mock juries, which brings me to answer your question. First of all, yes, I have done it, and I've got a story for you. First of all, let's put Kansas City, Missouri up on the map. To the second part of your question about why aren't they done and why aren't they done all that often, is they're expensive. They cost thousands of dollars to put on, because you're not just hiring the agency to put together the mock jury. You have to hire an entire, usually it's like a jury consultation firm, or, there's a bunch of outfits that do these mock juries. They got to be paid, but then you got to pay all the potential jurors to come in and sit and listen and spend a half day or a full day listening to this stuff. They all need to be paid. So they're expensive. That's why they don't happen all that often. They happen much more often in civil cases involving huge corporations who've got money to burn. They'll do mock juries all the time. Criminal cases involving, independent clients, individuals paying out of pocket, usually don't have the money. I did have the fortune of having one client who did have some deep pockets and did want to do it, and it was incredibly helpful. One, it's helpful to try out your arguments in front of a jury and to get people's actual reactions. That's the most obvious point, right? Is that you're going to get people talking about your arguments and how those arguments bounce off of them and how they feel about it. And it really was like you may have seen in the movies. Like, we presented opening and closing arguments to two different potential jurors, and then we had them deliberate. And we're watching them through, that two-way glass talk about the case. And it was very educational to hear what stuff stuck with them, what stuff didn't. You get into your own, tunnel of confirmation bias where you think a point is really good and it might be completely lost on jurors. So it was very fascinating to hear all of that. But I'll tell you, the other part about it that was very valuable was the reality check it gives to your client. Clients, defendants tend to believe in their own case more than they should. And they tend to believe we just need to convince a jury. We just need to get in front of 12 people. And once they hear my position and my side, I'm going to walk out the door. And then they watch a mock jury rip them to shreds and quote unquote convict them in that mock jury. And they are not as confident and are much more inclined to start pursuing plea negotiation, which we'd been trying to convince them to do for a long time anyway. So that was a really nice kind of side effect to all of that, and to give them an idea of the uphill battle. That, like, by the way, if we go to trial and we don't prevail, you already kind of might know that's coming. Don't be looking at me like it's my fault. It's your fault for all the stupid stuff you did that got us here in the first place. But I remember it also is a, if you're just interested in human psychology, just wild for the kind of preconceptions you might have about how certain people might react to certain things. And the case that I did it in, it was a case involving allegations of sexual assault. And you might have the idea ahead of time going into that men might be more favorable to a male defendant accused of something like this, and that females might align themselves more with a female victim accusing someone of this. We found that not only is not a true across the board, but is sometimes proves to be the opposite. We found that the males were much more inclined to be really critical of a male defendant because I think it was one, they didn't ever want to associate themselves with somebody who had been accused by something like that. We found that the male jurors in this mock jury were the first ones to speak up and be like, I don't think anything that guy did was right. I want to make that abundantly clear. And that was a little shocking to us, kind of the vociferousness of that coming from some of the male perspective jurors. And the females were a little more critical of, well, why did she behave a certain way? Or why did she do certain things? Because they're kind of putting themselves in the position of the female. Again, not across the board, but we were shocked by some of the reactions that we didn't think to be typical. So the other added benefit is it kind of gives you some guidelines on what kind of jurors you might be looking for if you actually have to go to trial. So great question, CB Kansas. Appreciate you asking. And it was a fascinating experience that I wish I had been able to do more often. I always thought maybe if I didn't become a lawyer or other things don't work out, maybe even just being someone who puts on mock juries might be an interesting line of work to get into. All righty. Let me see. I got my next one lined up here.
Hello, Joshua, crew, mods, chat, guests. It's Alicia K. Mayo from Humboldt, Tennessee. All right, Joshua, I'm going to ask because I haven't heard anybody else talk about it, and I deep dove on the internet, and that can be a scary place. So tell us what's going on with Smokey Robinson. Thanks. Happy Sunday fun day, y'all. Bye.
Alicia K. Mayo, hailing from Humboldt, Tennessee. Always good to hear from you. I love hearing your voice. You want to know what's the latest on Smokey Robinson? If you guys haven't heard, Smokey Robinson, the Motown icon, was accused by 4 former housekeepers in a $50 million lawsuit. And they're saying that between the years of 2007 and 2024 that he had been taking advantage of them, not only for kind of work violations, but also for sexual assault related allegations. They said that during that time he had been inappropriate with them. Based upon that lawsuit, the LA County Sheriff's Department did open an investigation. And that's all we know, is that they've opened an investigation. We don't know if that's gone anywhere. The latest is that Robinson turned around and filed a countersuit against these 4 women for $500 million for defamation, and saying, so he's come out swinging, saying, not only is this not true, but you've defamed me and I'm going to sue you for it in a cross complaint. In response to that, the lawyers for the housekeepers filed what's called an anti-slap motion. And these are really interesting. You may have heard these come up before. In California and some other states, they have what are called anti-slap laws. SLAP is an acronym standing for Strategic Laws Against Public Participation. And basically what they say is you cannot sue someone basically because they've invoked their own constitutional rights. So the argument being these housekeepers have the right constitutionally to make allegations against you, and you cannot, with all your money and power and high-priced attorneys, shut that down by just countersuing them, which would have the effect of freezing anyone from bringing lawsuits like this. You did jump down a rabbit hole on this one, Alicia Cameo. So if they win in this motion, that will shut down his entire lawsuit. So it's a really interesting kind of development here on what's going to happen next, because a $500 million lawsuit is 500 million reasons why people might drop their lawsuit or settle out of court and get this whole thing done. So we'll see if they win this anti-slap motion, then he's in deep trouble. But if he wins it, then I would not be surprised if we hear about some undisclosed settlement coming out of this whole thing. But kind of a sad thing. I'm a fan of Smokey Robinson. He's, put together some incredible songs that we've all heard of in the past. But if these allegations are true, it sounds like he was up to some bad business for the last few years. So we will keep an eye on that one. Thank you so much, AKM from Humboldt, Tennessee, for calling in. All right.
Hi, Josh and the team. You are my favorite out of all the analysts out there. A question regarding Kohberger. So I've got a strong suspicion that defense team would be doing the leak because I guess obviously there would be the winners here because they either get mistrial or extra time. If it is what happens, if it's not them, if it's like police from the other state, sorry, I'm from Australia, Melbourne, so I have no idea, I can't remember. What happens then? I mean, it's not prosecution's fault. They can't control every single policeman or every single person on the planet. What happens then? Anyway, my nick is, I'm a subscriber. My nick is, subscriber? Yes, it is. My nickname is Jimmy's Oxygen. I know, everyone's gonna hurl. There's a meaning behind it. And my actual name is Runak, and I love your show. You're my favorite, absolutely. And hi to the crew as well. Oh my God. If I hear my voice, I think I'm gonna vomit. Anyways, thank you. Bye.
Oh, Runak from Melbourne, Australia. Thank you so much. I love hearing your voice. Please call in more. Let's put Melbourne, Australia on the map. Our friends down under, Aussie. Thank you so much, Runak. You asking a great question, and it is about whether or not what will happen if the development in all of this is that law enforcement was the leaker. And as I always say, Runak, there are some questions I might not be able to answer with all of my research. And though I might be stumped, I am never beaten because I can always phone a friend.
Hey, Runak, this is Chris, and Josh asked me to help with the answer of whether or not law enforcement had leaked the information in Bryan Kohberger. And hello from Southern California, actually. That's the Pacific Ocean right there. And so I know you're in Australia. But here's the answer. So if law enforcement is found to have been the leaker in relationship to the Dateline information, then they could get into some serious trouble, because it's a violation of the court order, which potentially could be a misdemeanor in the state of Idaho, I'm assuming. But it all depends the damage that the judge feels took place. So anyway, they could get in trouble, they could go to jail, or they could be fined and held in contempt of court by the court. So anyway, you see the joggers going by. I'm right down here at the beach, and I hope that answers your question. Have a good one.
That is our good friend Chris McDonough from the interview room. A big shout out and thank you to Chris. Next time, if you guys are not fans of his already and you're not a subscriber, please go subscribe. And if you do, leave him a message on his latest video saying thank you from Courtroom Confidential for answering the question. I always appreciate everybody spending a little time to send us a video. Great question. As you heard from Chris, it could be bad news, Runak. If this comes from law enforcement, it could be really bad news, because we're not just talking about, sanctions. We're possibly talking about crimes being charged. But my worst case scenario is that if this is not only law enforcement, but somebody closely involved in the investigation, the defense is going to want to know that, and the defense might start challenging some of the evidence if this was recovered by the leaker. You imagine if the leaker was the person who recovered some of the most important evidence in this case. You imagine, I hate to be hyperbolic and set everybody's hair on fire, but you imagine if the leaker was the detective who recovered the sheath. Now we've got major problems. No indication any of that is true. No indication that it even came from law enforcement. We don't know. We hope to get to the bottom of it, but there could be varying degrees of awfulness depending on who, in fact, is determined to be the leaker. Runak, love hearing from you. Hello to Melbourne. Please call in again. All right.
Hey, Josh, this is Kathy. I got a question. In all your years, whether defense or prosecution, have you ever had a directed verdict be granted? Thanks. Bye.
Kathy, I have been waiting through several Sunday fun days just for a question like this. Kathy from Brunswick, New York. Let's put you on the map. She asked the question of, have you ever experienced a directed verdict? And what she's talking about is, we saw this argued recently, in fact, in the Karen Reed case. Anytime the prosecution puts on a case, if the defense feels, and they will make this motion in every single case, by the way, but if the defense makes the argument that the prosecution has not proven their case without the defense putting on a case. In other words, the defense has no burden. The defense can sit on their hands the entire time. It's all up to the prosecution to prove their case beyond a reasonable doubt, because everyone's presumed innocent. And if they don't meet that burden, the case should be kicked out. And so what you're saying is, judge, we don't even think this should go to a jury. They haven't proven their case. You see that clear as day. And so therefore kick this out before we even get to a jury, because you shouldn't make us go through the trouble of even putting on a defense case or even making arguments and closing arguments. This should be a directed verdict. The judge should step in and do the right thing in the interest of justice. These things are incredibly rare. Incredibly. I have never seen one. A colleague of mine had one granted against him as a prosecutor, and he agreed with it. He was like, my case was garbage. It fell apart in the middle of trial, and the judge did the right thing. So incredibly rare. Oh, June, you are so fantastic. Thank you again for the memberships. Very generous and kind of you. But The reason I love this, Kathy, is you give me the excuse to pat myself on the back, because for my first trial ever as a defense attorney, I got a directed verdict in favor of my client, which I am very, very proud of. In California, it's called an 1118 motion. And I had a case that I did not want to take to trial. I was against it. I did not like my client. I told him I didn't want to take it to trial. I told him he needed to take a plea deal. I was kicking and screaming going into this trial. But once we picked a jury, I put on my big boy pants and I put on a hell of a trial, to the point that after the prosecution case, I made a heck of an argument to the judge and he agreed and granted it. And we walked out the door with an acquittal without that ever even heading to a jury. So it was a highlight for mine as a defense attorney. Probably something I will not achieve again because they are so incredibly rare. But it was a case involving, just so you guys get a little bit of an idea, it was a case involving, and thank you all for the congrats. It was a case involving like obstruction, resisting arrest with police. And it was a stupid case. It was a gentleman who had basically been a thorn in the side of a local government and had called the police on people. And he was just a real pain. And when the police came out one time and they were asking him questions, he's refusing to answer. And all of it's caught on videotape and badge cam. And he's just being a felony a-hole more than anything. And they arrested him, and then they charged him with this BS resisting arrest and all of this other kind of stuff. And once it all came out in court, and once we were cross-examining officers and everything else, that became painfully clear that this was just a political crusade by that local community, and the judge did the right thing. So thank you, Kathy from Brunswick, for giving me an opportunity to brag about myself without sounding like I'm bragging about myself. All right. Let's keep it going here. Oops, hold on. All right.
Hi, everybody. Happy Sunday Fun Day. Okay, so this is Karen Reed question. I'm going to try to stay focused. My question is, now it's based on the fact that the state or the Commonwealth had arrested, and now we get the defense. And this first witness that they put on, his first name is Matt. He's, just everything, dreamy in every way, smart, honest. So my question is, even though some of his answers were somewhat helpful to the Commonwealth, wouldn't you rather have an honest witness like this young man was than somebody who's saying exactly what you want, but who is necessarily not being honest like the Commonwealth had? I know it's a little bit of a jaded question, but yeah, that's my question. Thank you.
Sonia, I think you were so excited about your question. I don't know if you said your name or location, but I know this is Sonia from Chicago. Thank you for asking. Best gun losing detective. Thank you for the question. Says, ask Scott from Recovery Addict. He covered a case with a granted directive. Oh, interesting. Oh, maybe I will ask him about that because they are rare. So he actually watched one. That's incredible. Yeah, they don't happen that often because if they do, if you think about it, that's a complete breakdown in the system. What that's saying is that is where the prosecution has failed to realize how bad their case was. Now, sometimes things happen in the middle of trial that you don't expect and the case falls apart. But if you've got a case that's so bad that you can't get past directed verdict, what are you doing filing that case in the first place? Anyhow, thank you, Best Gun Losing Detective. Sonia, let's get back to your question. Karen Reed, calling from Chicago, Illinois. I think we found out last time you're a Cubs fan, isn't that right? Go Cubbies. Well, go Dodgers. I don't know if you guys, just as an aside here, 18-2 against the Yankees, and we're supposed to be worried about a rematch. I mean, come on here, folks. Cubs are my second favorite team because I lived some time there in Chicago and loved going to Cubs games. But man, these Dodgers, boy, And they are looking strong. And our entire pitching staff is injured. Did you guys know we were going to turn this entire thing into a sports podcast? Buckle up. Anyhow, I tried bugging Joel from Surviving the Survivor this morning because he's a big Yankees fan. And by the way, if you next time you guys are on his channel, you should bug him because we made a bet about the World Series and he was supposed to be wearing a Dodgers hat in one of his live streams, which he still has not done and I have not forgotten about. But the Dodgers played the Yankees last night and they went down 18-2. 18-2 Dodgers over Yankees. And I texted Joel this morning saying, I am so starving for a big breakfast. I think I will have 18 eggs. How many are you going to have? Oh, just 2. And I didn't get the appropriate response from him. Anyhow, your question, Sonia, about experts. Your question is basically, don't you want an expert to be honest rather than to be helpful? Well, hopefully they're helpful anyways. Yankees fan here. Hank's worn out eraser. Yankees fan here. Love you guys. Game 3 tonight. We'll see if we can sweep it. But don't hate on me and please continue to come back. Anyhow, the answer is, Sonia, of course you want them to be helpful. You hope that they're helpful, but I think you're right. Honesty is the best over everything because jurors, they're like us. They can see through this nonsense. They can see through the BS. They can spot bias from a mile away. And they know they're not fooled. They know if an expert is just giving the answers that the one side wants them to give. They know that that's not an unbiased expert. And it really doesn't matter about who's getting paid or not. They can tell, just like all of us can, if an expert is not being honest and is just biased about their opinions. And I'll tell you this too. In my experience, jurors do not care as much about the expert opinions as you might think. In other words, these experts, the Karen Reed case is a great example. You've got experts for the Commonwealth who are going to say, I believe Karen Reed killed John O'Keefe by hitting him with her car. That's my expert opinion. Here's my resume. Here's how long I've been doing this. Here's all the education I have. Here's why I should be believed above everyone else. Then you're going to have the defense put on their experts. And they're going to say, there is no way in the universe of physics as we know it that Karen Reed's vehicle killed John O'Keefe. Here's my resume. Here's all the experience I have. Here's all the accolades and everything I've ever received. And here's a picture of me and the president. And the jurors are going to say, I believe a little bit of that guy. I believe a little bit of that guy, but they base it upon the whole case and all of the evidence as it's presented. And I have never experienced a case where jurors have completely just substituted their own decision based upon what an expert told them. So you hear a lot about, this is a battle of the experts and all of that. I really don't think it is. I think at the end of the day, the jurors are going to make a decision based upon a lot of other things and probably more on other things than just on these experts' opinions. I think the experts are helpful for them understanding some of the technical stuff involved, but I have yet to see a case where an expert has won or lost a case purely on their opinion. Anyhow, great question, Sonia. Go Cubs. But mainly, the Dodgers, they could sweep the Yankees here. It would just really be fantastic. All right, let's keep it going here.
Hi, Josh. This is Maureen from Monterey. I've already left you a message, but I just watched your Friday update and you said you needed more. So I do have a question I've had for quite a while and I thought I'd leave it. And if you need to use it, use it. If you don't. But I have had this question. I don't know, 2 or 3 months ago, I watched an episode of a show. I think it was called LA Homicide, and it was about the Phil Spector case. And there was a detective interviewed in that series who, when he walked into Spector's house and saw that it was full of rats and cockroaches and disarray, and he saw poor Lana Clarkson sitting there, dead. And he quit, if I'm recalling it correctly. He apparently quit the police department, I think. And he made the comment that everybody has a number. And I think what he meant by that was, you can see X number of cases and you're fine. And then you reach that number and you're done. You don't want to see it anymore. So I was wondering, have you ever felt like you're reaching that number? I know you've seen horrible things. I know you're very good at what you do, but do you ever think you have, or you will? Or I've just been curious about that ever since. So thanks a lot, Josh.
Thank you so much, Maureen from Monterey, California. Always love hearing from you. Let's put Monterey on the map again. This is a great series, by the way. If you guys have not seen it, it is a series. Season 1 was homicide in New York, and they followed around a bunch of different cases and detectives and prosecutors out of New York. Season 2 is homicide Los Angeles, and it's so funny because I know practically every detective on this show. I didn't even know they were filming this thing, and then all of a sudden it's like, I know that guy. Hey, I worked with that guy. And the first case up is the Phil Spector case, which have a very close history with. If you guys don't already know, the reason I know Alan Jackson is I was his law clerk on this case, however many years ago. What are we going back? 2008, I think it was when this trial was. I hope I'm not wrong. That would be awful if I'm getting this wrong. I think it was 2008 was this trial. 2 trials, hung jury the first time around, second time around, a conviction against Phil Spector for shooting and killing Lana Clarkson inside of his home. I wonder if Josh saw the Spector crime scene in person. I did not see the crime scene. I've been to the home, but I've not seen I guess the crime scene where it all took place, but I was not called out. In other words, Alan was when the shooting took place. But anyhow, really fascinating coverage of that case. If you have any interest in the Phil Spector case, or just kind of the way, some other really high profile cases taking place here in Los Angeles, Alan is in that series. He was interviewed along with the detectives who were involved in it. And I don't remember this detective making this comment, but your question, Maureen, is one of the detectives makes the comment that everybody has a number. And I've heard that phrase many times before from detectives. Everybody's got a number. When we were talking to Joe Giacalone, he talks about when you talk to detectives about how long have they been on the force, nobody says how many years they've got in. They all say how many years they have till they're done. So, how long you've been a cop? I've got 2 years till retirement. They're all looking for the end of their career because it is something that can burn you out. And have I reached that number? I'll tell you what, I enjoy doing this. I think that's part of why I'm pursuing this in a world outside of the stress and pressure of sitting next to a client who may be going away to prison for the rest of their life. It is a lot more enjoyable to be talking about and analyzing these cases where you don't have the sleepless nights of what are you going to do if you don't get this one right. And I think that, that's why hopefully we can make this thing a full-time gig for me, and I can retire from the actual showing up to court every day and arguing with judges and getting yelled at and all that other kind of stuff. It's stressful stuff. I know this wasn't Maureen's invitation to have a pity party for Josh, but it is very stressful stuff. The only kind of stuff that makes me stay up at night and my knot in my stomach is dealing with clients who are in a real bind. And what am I going to do? And how am I going to help these poor people? Because they've got significant changes that could be coming up in their life if I don't get it all wrong. It's not work. Yeah. Well, yeah. Thank you. Thank you, Simi. Gina Gilmore says Stacey Drake case out of Oklahoma and Arkansas is very in. He is identified as an armed career criminal, now suspect in 4 murders. Oh, wow. I've not heard of this one. And thank you for bringing that to our attention. I'm going to look that up. And I feel like I missed somebody else's comment. Maybe I did or didn't hear. Redondo Beach says, do you want an apprentice? Do you know anyone who's gone through law school that way? That's funny that you asked that, because that actually is, in some jurisdictions, a way you can become a lawyer is by apprenticing for someone for a period of time. So thank you for that. Those questions, both to Redondo and to Gina for asking and contributing. I appreciate you guys. And thank you, Maureen, for asking the question. And check out Homicide on Netflix, everybody. You would think I have stock in Netflix, the amount of times I promote their stuff, but I don't.
Hi, it's Joy again. This is just an addendum or clarification of my question. I guess I was thinking of the verdict form as well as the jury instructions. Sorry about all that.
Sorry. I missed Joy's first question. Here we go.
ICC crew, it's Joy W. from Ottawa, Ontario, Canada calling. I just got finished watching the Friday members only video, and you said you needed a couple more questions to round it out. So here goes. You have said that a trial can be won or lost at jury selection. But my question is about jury instructions. Just wondering if there's a template for each sort of charge, and how much the negotiation and how much you can tailor the instructions to the jury, and how much that impacts on how the jury determines the verdict. Anyway, I hope everyone has a great rest of their Sunday. Thanks. Hi, it's Joy again. This is just an addendum or clarification of my question. I guess I was thinking of the verdict form as well as the jury instructions. Sorry about all that confusion. Anyway, everybody have a great day.
All right. Sorry about that. And I wanted to say, where is it here? Somebody, I just saw somebody became a member. Full-throated motion. I like that name. Full-throated motion. Thank you so much for becoming a member. Appreciate you. Sent your link to that case, Gina Gilmore. Oh, thank you. Appreciate that. I will look into it. I appreciate that. Okay. Joy from Ottawa, Ontario, Canada. Let's put you on the map. Hello to my Canadian friends. Jury instructions. How important are they? They are, first of all, yes, there's a jury instruction for every charge. There's a jury instruction for everything related to a case, how to consider evidence, how to listen to witnesses, how to, if you've never heard the judges reading out in jury instructions, they can go on for an entire day sometimes, depending on how complex the case is. They're incredibly important. And they are the most common basis, I would argue, for an appeal, is that the instructions weren't proper, that the jury wasn't properly instructed. Almost every appeal, if there's an issue, X, Y, and Z took place, and that was a problem, the appellate court will go back to the jury instructions and see if the jury was instructed on that properly. Was that issue addressed? Was the jury given an opportunity to understand how they should treat, either a piece of evidence or an issue that took place in court, and how did the jury instructions address that? It is funny to me, because sitting in court while the judge is reading the jury instructions, and in California, at least, judge will actually read them to the jurors and then provide them with a copy of them. The jurors' eyes glaze over. I mean, it is just one of those things that is just kind of a pro forma thing that we go through, but it is funny because of how important it is. The jury instructions are incredibly important. Joy also asked, can they be tailored? Yes, they can. there is a lot of litigation behind jury instructions. And so every jurisdiction will usually have a set group of jury instructions. In California, we call them CalCrim, that judges and a committee of people and litigation and case law have gone into forming these things to hopefully be exactly right. But sometimes they don't fit every situation and they have to be tailored. And there will be a lot of discussion between the parties about how to construct them and tailor them to meet the factual scenario of your case. And then sometimes there are crimes that don't have a specific jury instruction, or an issue that doesn't have a specific jury instruction. And attorneys will oftentimes ask for what will be referred to as a pinpoint instruction. Your Honor, we want a pinpoint instruction on this particular issue that's not in the jury instructions manual. So we want the judge to construct a instruction, and that will take a lot of time. And it is because they are so important, because they are really the roadmap, the instructions, the manual for the jury of how they should decide the case. And if that's not done right, there can be problems. And that's what oftentimes is pointed to in appeal. And then your follow-up question about the verdict form, same thing, probably not as much debate and consternation over those, but verdict forms too are something that each attorney has to sign off on. They have to review. They have to make sure that they're clear to the jurors. And when they're not clear, you can have problems. And I think that was one of the main problems in the first trial of Karen Reed, is those jury verdict form was a little bizarre to me. I've never seen it done that way, and I can understand where it might have caused some confusion. Kathy Davidson says, I think some are clearer than others, and for being so important, I think they need to be very clear. The problem is, they need to be clear, but there's also just very particular case law on what they should say. So they end up sounding like a bunch of legal gobbledygook most of the time. And it's hard, and it's part of the good attorneys' job of kind of unwinding those instructions and making them make sense in layman's terms, because the wording of them is so highly litigated that they have to be worded a very specific way. I would not be able to pay close attention for such a long period of time just listening, but it seems so important. And most people are not. Most people sit there and you can just tell that they're barely keeping their eyes open. So great question, Joy. And thank you so much for calling from Ontario, Canada. All right, guys. This is it. Who's going to bring us home?
Hi, Josh. This is Crazy Mom RN from Tucson, Arizona. Love your channel and love Sunday Fun Day. It's my favorite day of the week to spend with the Courtroom Confidential crew. My question for you is about the upcoming Christopher Scholtes trial here in Tucson in October. Christopher is charged with first-degree murder for allegedly leaving his 2-year-old daughter to die in a hot car during 109-degree temps here in Tucson in July of 2024. He was originally charged with second-degree murder, but that was upgraded to first-degree by the grand jury in light of new evidence related to prior child endangerment and negligence. He was offered a plea deal for second-degree and turned it down. Christopher has been out on bond and is married to a local doctor here in Tucson. The judge recently allowed him, his wife, and 2 surviving children to go on vacation to Hawaii. My first question is, as a defense attorney, would you have advised against this vacation in light of the upcoming trial? And also, what is your opinion on the upgraded charges? Sorry for the raspy voice. I just happen to have a cold right now. Thank you very much for your answers.
Crazy Mom RN bringing us home. Thank you so much. So good to hear from you. Always love seeing your name, and now it's nice to hear your voice. Calling from Tucson, Arizona. Let's put you on the map. And what a wonderful question, Crazy Mom RN. You're asking about the Christopher Scholtes case. I pronounced it Scholtes. Kaylin tells me it's Scholtes. She's rolling her eyes at me because she's looked it up more than once and says it's pronounced Scholtes, but I don't care how many times I look at it. It looks like Scholtes to me. But Christopher Scholtes has been charged with something incredibly serious and about as heartbreaking as I can imagine. This case actually is difficult to even think or talk about. And Crazy Mom RN did a good job of laying out the facts. But basically, what happened is that in July of 2024, in Arizona, his 2-year-old daughter lost her life because he left her in their vehicle for 3 hours outside in 111-degree weather while he was playing video games. And he had left the car running with the AC on, but that vehicle, like many modern vehicles do, had a timeout setting that it turned off after 30 minutes. If you're just sitting in the car with it running, doing nothing, after 30 minutes, it's going to turn off. And she lost her life. And I can't imagine what that poor, oh my God. I can't imagine what that poor little girl went through. So it's just about as heartbreaking, awful a thing as can possibly be imagined. So to the first question, Crazy Mom RN, he was granted permission by the judge to go and take a vacation with his family. His wife is still with him and their remaining children to Hawaii. What is my thoughts on that? Well, my thoughts on that is that the optics on this case are so incredibly awful and bad already that the idea that you are going to the court to ask for time to go to vacation in Hawaii is probably not going to look good. Is it illegal? No. Is there something on paper wrong with it? No. If I am a potential juror and I find out about this, I'm probably losing my mind. And that, to me, is the biggest problem. Is, there's so much concern done about public perception and potential jurors and how will they respond, that if they hear about this, whether or not they've prejudged him on what took place, this might send them over the edge. Time and place, dude. I get it. I get that this man may be thinking, I may be going to prison for the rest of my life. I want to spend some time with my children. I want to put it all behind me and spend some time with my loved ones if this is going to be the last time I spend with them. I get it. Just not a good look. Extremely bad optics. But Crazy Mom's second question is that they raised the grand jury in Arizona. He was first arrested on second-degree murder. The grand jury convened and raised it to first-degree murder. Now, some of the things that the investigation has revealed was, one, his wife had warned him about this before. In fact, there's text message exchange between him and his wife where she literally says, I warned you about this. How many times did I warn you? His other children had made complaints about being left in the car by him before. His other daughter, his oldest daughter, had said that she had been left in the car with it running by him before, some 60 times before. I have little ones. Have I ever run inside the house to grab their stuffy that they left inside while the car was running outside? Sure. Are there parents who have run inside the store real quick while the kids remain in the car? Sure. 60 different times and all of their kids complaining about this, we're talking about something else entirely. And we're also talking about, this isn't a quick, I'll be right back. I don't want to unbuckle you from your safety seat, get everybody outside of the car so I can run inside and grab a Red Bull from the convenience store at the gas station before I get back in the car. We're talking about leaving them in the car for several minutes while he goes and plays video games. In this case, 3 hours she was left in the car. There was also evidence that he was aware of the fact that the vehicle would time out after 30 minutes. Those are the reasons why it was raised by the grand jury from second degree to first degree. He was offered a deal for second degree murder, which would have given him anywhere between 10 and 24 years, and he rejected that. First degree murder carries a life sentence. His trial is set for October. Here is why I think he took the chance and why he rejected, why he might be wanting to go to trial, though I still think he should have taken the second degree murder. But maybe he's just thinking, I'm going to get up there and testify and explain to jurors just how heartbreaking this whole thing is. I don't know. Obviously, we don't know what's going through this man's head, but we're talking about whether or not this should be a first degree or second degree murder. In understanding the degrees of murder, and not every jurisdiction separate degrees of murder, but in understanding all of that, I have found that the best way to get your head wrapped around it is to start off with second degree murder as being the default in any case of a homicide. In any case where someone loses their life, you start out with that being a second degree murder. And if there are certain factors in aggravation, it can raise it to a first degree murder. And if there are certain factors in mitigation, it can lower it to a manslaughter. And this is what I mean. If someone loses their life at the hands of someone else, you call that a second degree murder. If, however, you can show that that murder was deliberate and premeditated, meaning the person made a decision to kill and that decision was made before the act of killing, then you can raise that to the level of a first degree murder. You have a deliberate premeditated murder, first degree murder. Or if that murder was committed during the commission of certain types of felonies, certain violent or dangerous felonies, you can raise it to a first degree murder by use of the felony murder rule. In Arizona, I don't know if they have felony murder, but I imagine that might be the theory that the prosecution is pursuing. That is the felony of child abuse and child neglect, a felony that would qualify to make this a first degree murder. So therefore, all that they would have to prove to jurors was the felony child neglect. And in the course of the felony child neglect or child abuse, the crime of murder was committed. They're therefore making it a first degree murder. That could be the theory that they're pursuing and why he should have taken the second degree murder plea. If you don't have any of those factors in aggravation, then you stay with a second degree murder. Other acts of aggravation could be how the murder was committed. In California, things like torture, lying in wait, using an explosive device, using poison, all of those can raise it to first degree murder. Then factors of mitigation, lowering it to manslaughter would be if there was some sort of heat of the moment, heat of passion, provocation, that some person not otherwise disposed to commit a murder was provocated in some sort of a way that they then committed the murder in reaction in the heat of the moment. That could be a voluntary manslaughter. Or the mitigation could be that they had no intent, no criminal intent to commit murder, and it was much more of a criminal negligence, making it an involuntary manslaughter. So that is I hope you all took notes on that. I'm going to be asking questions. This is pass or fail, so I hope everybody gets it right. But to answer your question, to me, unless there's a felony murder argument here at play, it looks much more like second degree murder, not deliberate and not premeditated. And on that wonderful note, it's a wonderful question, but around a nightmarish case. Thank you so much, Crazy Mom RN, for asking it. That is our show for today. Oh, and we hit 34,000 subscribers. What perfect timing. Thank you guys so much for all of your support. Oh, well above 34,000. You guys are all fantastic. Thank you so much for being here. Let's do some quick announcements and then get you on with your Sunday. First of all, if you missed it, on Saturday, just yesterday, we had our weekly roundup. I hope you guys like that show. I hope you check it out every single week. We put a lot of work into it. This week, we talked about all the cases that you should be watching, including highlighting Karen Reed, Sean Diddy Combs, Maxwell Anderson, and of course, Bryan Kohberger. Stay tuned this week. All this week, if you want to watch a live trial and you are following the Karen Reed trial, you can follow it over on our sister channel, Courtroom Confidential live trials. We are watching every single day with all the cool kids in the chat talking about Courtroom Confidential. Donna Nelson, thank you so much for becoming a member. Speaking of which, memberships are open on the Courtroom Confidential live trials channel. So check it out. Become a member if you like, but join us in the chat, and I'm going to be poking my head in here or there to give commentary along the way. Then on Monday, we have the latest in our Courtroom Confidential conversation series where we sat down with Linda from It's a Crime. Wonderful conversation with her, really introspective, a lot of talking about, why true crime, the toll that it takes, covering it. That will premiere tomorrow, Monday at 5 p.m. Pacific, 8 p.m. Eastern. Hope to see you all there. And Linda will hopefully be joining us in the chat. Tuesday, I hope he's still here. I don't think he is, but I am going on Joe Giacalone's show, True Crime with the Sarge, and we're going to be having a live conversation. I don't know what we're talking about. I think he's just going to interview me, and we're going to ask questions and talk about true crime. So that will be on his channel, True Crime with the Sarge. Check that out tomorrow, or pardon me, on Tuesday. Wednesday Night Live, as always, 5 p.m. Pacific, 8 p.m. Eastern. This week, our special guest is going to be Gigi from Pretty Lies and Alibis, and we are going to be talking about the newest Lori Vallow case, the never-ending saga of Lori Vallow, and now she is charged with attempted murder of Brandon Boudreaux out of Arizona again. She's again representing herself, and Gigi has been following that case closely, so we'll be talking a little bit about that this Wednesday. And then finally, some sad news. Next Sunday, we are not doing Sunday Funday. We are skipping next Sunday. We've got a bunch of other things that we're working on, and we just could not make it work. But please leave us your questions and comments as always. We will be back the following Sunday. It's just this Sunday. We got to take a little micro break. But in the meantime, where can you go and leave us a message? You can always go to thecourtroomconfidential.com and click on leave us a message, this tab over here, this box will pop up, and many of you have done that, and we hope that you continue to do that. If you want to join our membership program, you click on become a member and learn about all the benefits of that. And we really try, guys. We really try to make the membership program on this channel something that you feel will be absolutely worth it. So please check it out. And then as always, you can click on our shop and check out all of our new merch. What am I wearing, Tiffany? What is this called? I'm guessing this is called Popsicle Summer Popsicle Paradise. I don't know. She's not answering me. She's ignoring me. It's called Tiffany Blue. Oh, Tiffany Blue says best, Nancy. Maybe that is what it's called. Mint Cloud or something. I don't remember. All right. Well, if you want Mint Cloud or something or any other color, please check out our shop. In the meantime, you guys are all fantastic. Thank you so much for being. Sorry. Thank you guys so much for being here on a Sunday and spending some time with us. I appreciate you all. Thank you so much to our mods, Afton and Shy Gal. And thank you to Kaylin and Tiffany in the background, keeping everything. Chalky Mint. Okay. Never would have guessed that. Thank you, Tiffany and Kaylin, for being in the background and for doing everything that you do. This was a great show. Really enjoyed it. And we will see you guys soon. Have a great Sunday, everybody.